Our next speaker is one of the most interesting thinkers in gamification, but comes at it from kind of an important and unusual angle. James Gatto is one of the foremost experts in the law around virtual currency and gamification. And normally, I will say, after having worked on a number of events, the lawyer talk is often one of the least exciting talks in a lineup. You're like, oh, it's the lawyer talk. I'm going to listen to a lawyer talk. But actually, in this particular, and I grew up with a lot of lawyers, in this particular case, we have a really interesting confluence of factors that makes this talk especially important. The first one is that Jim is an awesome speaker, and he knows more about this subject than just about anyone else in the world. The second thing is the law for virtual goods, virtual currencies, and gamification is in tremendous flux for any of you who have anything to do with the subject of actually deploying gamification in the enterprise or in startups. And we're really, really pleased to have Jim here. So he created and leads the virtual worlds and video games team at Pillsbury Winthrop. He's the leader of the open source team and used to head the intellectual property practice there. And so with all that having been said, I'm really, really excited to have Jim here to talk about legal issues in gamification. Jim? Thank you.
Okay, hello everybody, and it's a pleasure to be here, and thank you, Gabe, for that wonderful intro. Let me ask you first, how many of you had the opportunity of working with lawyers in connection with your business? All right, keep your hands up 1 second. How many of you actually enjoyed that experience? A couple of hands, that's pretty good. That's more than I usually get, so it's nice to have a little bit of a sympathetic audience. I appreciate that. Well, you know, there's a lot of reasons people don't like working with lawyers, particularly when you're entrepreneurial and creative and working on new business models and things that are innovative. And part of the reason is that there's a tension there in that you're trying to do things that are new. As Gabe said, the law is in a state of flux, and the law is always behind technology. The law is always behind new business models. And many lawyers believe their job is to tell you what you can't do. They want to avoid risk. They want to make sure that nothing is done that will come back to them and say, with our lawyers asleep at the switch, how'd you let these people do this? Really, what it comes down to, it's about balancing risk. And there's a number of competing factors that really need to be taken into account, really, when you're kind of looking at both the business opportunities and the legal risk. And it's not about it's about how can we achieve our business objectives and manage that risk. And there's a number of different components that go into that equation that are really important, and it is kind of a balancing, right? So there's always you want to maximize user experience. That's always one of the goals, right? You want to make it as fun for users or as beneficial for users so that you achieve your business objectives. You want to maximize your revenue or other business opportunities. And those are always typically countered by, how do we protect our assets? How do we protect our platform or our brand? Or the other factors of your business that you need to protect. And how do you protect your users, right? It used to be, when the web started, you had a user went to a website and it was a one-to-one transaction between a business and a user. And you could govern that experience to a large extent. With open platforms and social networking and all the different business models that are there, it's a lot more complex now because many times your business, there's third parties that are providing services or benefits to your users. The users are interacting with one another. And so you need to have an ability to protect your users to protect your business. And of course, you want to avoid your own legal liability, both from the standpoint of suits from customers or from regulators. And so there's a whole combination of factors that go into kind of balancing these risks. And because so many of the things that all of you in this audience are doing are so innovative, and because the law is so behind, very rarely are things black or white, right? There are certain things that are clearly criminal at one end, clearly illegal at another end, and then clearly things that are permissible. But there's a whole range of gray in the middle. And trying to find the right balance is really one of the key things that we help companies focus on. And it's hard to do that without really understanding not just the law and the analogous precedents that have happened in the past in situations, because many of the legal issues that are being squarely confronted now just haven't been litigated in court yet. So you have to look at prior precedent. So you have to understand what's happened in the past, how does it apply to what's happening now, and then also look at kind of where are things going or what could go wrong from a business or legal perspective. It's really hard in about a half an hour or less to actually kind of cover all this. I'm going to give you some examples of things where some of these issues may play out. So one example, so from a user experience perspective. So there was, I think one of the earlier talks talked about WoW, World of Warcraft. So one of the things that happened early on, and some of you may be aware of this, is that because anytime you're creating value, right, and you're trying to do that with gamification, whether it's points or other components, there's value there. If there's real money to be made from something, people will not only do what you want them to do, but you'll also find people who are going to game the system and just try to profit from it. And you want to try to protect against that. So one of the problems that Blizzard faced with World of Warcraft was that, as we heard earlier, many of you are probably familiar with that. For those who aren't, there's levels you have to go up. And your game experience gets better as you go through levels, but you have to slog through those levels. And it can take 600 hours to get to certain levels where it really becomes fun. Well, there's certain people who have more money than time, and rather than go through that experience, what they'll do is they'll buy an account. They'll buy an account that's been leveled up. And there was companies that actually went into business and took people in third world countries, paid them pennies a day to just sit there and play World of Warcraft, and you'd have accounts that got leveled up, and they'd be sold for thousands of dollars to people who just wanted to start at one of those levels. Right? Those were sometimes referred to as secondary markets. So the problem with that is that it impacts the integrity of the system. We talked a lot today about competition, and that's part of what drives user action. And if you can sit there and have to slog away and achieve a certain level, and someone can come in and buy it, it takes away the fun from you of trying to get that achievement. So there's certain things you may want to do to try to protect against all these different models. How do you make sure people don't game the system so that it adversely impacts the user experience you're trying to create for the people who are playing by the rules? So that's one example of user experience that World of Warcraft faced, and there were a whole bunch of lawsuits on that, and that kind of played out in that context. We look at business opportunities versus liability. So another example, many of you are probably familiar with Second Life. One of the things to think about is most of you focus on the positive. There's tremendous business opportunities. There's tremendous upside, and I think the last panel was talking about how, let's think about how we can get users points, and sometimes people think afterwards, well, what do they do with those points? How are we going to create sinks? How are we going to make those points worthwhile so that people stay engaged? Well, one of the things you need to think about in balancing the business opportunities and potential liabilities is what can go wrong, right? So one example of Second Life, there was an example early on. In fact, it was a lawyer who had an account with Second Life, and he found a way to actually buy land through some of their auctions. By using an exploit, he was able to actually change the URL and buy land that wasn't actually up for auction yet. And so he was basically the only bidder, and as you might suspect, he got pretty good deals. Well, Second Life terminated his account because it was against their terms of service, and there was a lawsuit involving that. But the problem that illustrates is the following: is that Second Life, their model was they were advertising, and they've actually now changed this, is that you can make real money, right? Buying land, buying virtual goods, and the problem was that this individual, his name was Mark Bragg, he had tens of thousands of dollars worth of virtual goods and land in his account, and got his account terminated. And the terms of service said that if you're, that because the assets were really only used in Second Life, if your account was terminated, you basically lost the value of that. And he said, okay, fine, if you terminate my account, you can terminate it, but I want the value of my goods and services. Well, if every time someone does something illegal on your system, you have to pay them the value of their points or their virtual goods or virtual currency or land, whatever, right, that's a potential problem. And so there's ways of dealing with that, and that lawsuit kind of highlighted some of that. But a lot of people don't think about like the downside of what happens when you lose a customer or you have to terminate them. So there's an example there of how in the terms of service you want to protect against that. And I'll talk about another example of a Second Life case in a little bit. One of the other things that we see, and again this has been talked about a little bit today too, as far as protecting your assets. Right now, there's a lot of people trying to do the same thing. There's a lot of competition, and to a certain extent that's good. Competition is good. The best business model is going to win. The problem is there's also a lot of copying, right? And so some people who come up with very innovative ideas, right, they deserve to benefit from those ideas. Now, others may build on them and add to the overall intellectual property pool, and that's a good thing too. But people who just pure out copy, that is, there's laws designed against that. The problem is you need to take steps to protect yourself so that you can avoid that, right, through patents, copyrights, and other forms of intellectual property. One of the biggest problems that we see is that many people believe nothing in this space is patentable. There is a lot of patents being filed in this space. So if anyone has that misperception, you should talk to someone who kind of understands what is and what's not patentable, because what we're seeing is more and more patent activity, and what invariably will follow as companies get big, you're going to see more and more patent suits. It happens in every time there's new technology and new industries or new business models, there's this pattern of IP gets filed and the lawsuits filed once there's enough money to really fight about. We also see a number of things. Many companies are working with developers, contractors, et cetera, and this cuts across not just gamification, but many other areas that we see as far as misperceptions and when it comes to copyright. Many people correctly understand that copyright protection exists from the moment you create a work in a fixed medium, is the legal mumbo-jumbo. I try to avoid using a lot of that. What a lot of people don't realize is that by filing copyright registrations, you get two really key advantages. One is, and you have to file them timely, within 3 months typically of publication of your work, is that one is if you have to sue somebody, you can get attorney's fees, whereas if you don't have it timely filed, you don't. And the second is you can get statutory damages. And what that means is that instead of having to prove what your damages are, a judge can just say, I award up to $150,000 per infringement. And the reason that's important is that we see a lot of situations where someone comes to us and says, hey, this company is copying exactly what we're doing. We look at how much money is at stake, and the legal fees to enforce that action is more than how much is at stake. And so you're left with a bad choice of either we spend more than we're going to get, or you let it go. If you let it go, then it will get worse and others will copy, and then the cat's out of the bag and it becomes almost too hard to put back in. So by having a comprehensive IP strategy up front, you can put yourself in a position that you maximize the benefits that are built into the system if you take steps in a timely action. One of the other big issues that we see, and how many people have seen the movie Social Network? All right, just a few, right? So, you think about that from the beginning, right? I mean, whose idea was what ultimately resulted in this concept, right? I mean, there was not really effective intellectual property protection from the originators of the idea, and we all know the story that's kind of played out from there. One of the things we see with respect to ownership of IP is people just don't address that up front, and they don't address it effectively up front. And one of the areas where there's a lot of misperceptions is with respect to work for hire. Very common to go out, hire developers to work for you that are not employees. And many people believe that if you pay for work and someone develops work for you, it's work for hire and you own it. That's not the law. There is a concept referred to as work for hire. But the thing that most people, and the biggest misperception we see when it comes to software, is that there's certain categories of types of copyrights that work for hire apply to. Software is not one of them. So anyone who relies purely on work for hire may not own what they think they own. And where we see this play out primarily is when either a company is going for funding or an exit they're going to sell, and IP diligence is done, and you have to make the reps that you actually own all your IP, and you find that you don't own all your IP. And that's not a good time to find out that you have a problem. So again, all of these things can be addressed by having a competent attorney understand what you're doing, map out the legal issues, and guide you on what can and should be done at an early stage. A couple of issues with virtual currencies. I mean, this is a topic that one of the biggest issues I will tell you is that while there's phenomenal opportunities out there, and many people think that if there's no cash in, if you're just rewarding people with points and they're not paying for it, there's really not that many legal issues. That too is a misconception. It really matters to a certain extent, really what is the overall structure of the system with the virtual currency. Is it a single currency or a dual currency? How are people acquiring the currency, and what can they do with it? In many cases, as we know, virtual currency can be used, whether it's for virtual goods or something on your site, or can be used for third-party purchases. There's a value attributed to them. And even if there's not effectively a cash-out mechanism, many times what people are doing is they're selling their accounts, they're selling the virtual currency, or there's a secondary market that's developing, and it impacts some of the legal issues. if you have a currency, either a dual currency system or a currency where people are paying for currency, there is really almost every state has laws that apply to that. Many people don't understand like all the laws that do apply, and there's actually some federal regulation as well. Some of the common issues that we see with virtual currency, and let me say before I go into this, the other big thing we see with virtual currency is this, is that there is a ton of legal issues. There has not been much regulatory enforcement yet. I'm based just near the DC area, and we've actually been contacted just in the last few months by a number of different government agencies to help consult with them with respect to them looking at this, because they understand there's billions of dollars of currency moving through the virtual currency markets throughout the world, and there's a lot of it's legitimate, game-related activity, and a lot of it is bad stuff that's going on right now between money laundering and terrorist financing and everything else. Department of Homeland Security is looking at it. The FTC is looking at it from the standpoint of consumer protection and others. There will be more enforcements going forward. And the biggest problem we see right now is when we sit down with companies and we talk to them about their virtual currency system and how they have it structured, is we explain to them what the laws are, what the risks are, and what they're doing right and what they should do differently. The most common answer we get is, yeah, but so-and-so is doing it just this way, why can't we too? Well, the answer is you can, but you're going to be sharing the same risk that they do. I mean, do you want to be the one who's the test case, or do you want to be joint defendants when there's an enforcement, or do you want to try to manage the risk? And that goes back to what I said in the beginning. Some people are willing to take more risks right now, but what we advise is that you at least understand the risk and you balance the business opportunities and the upside with the legal risk that you're taking in doing that. And at a minimum, understand where criminal liability comes in, because there are some with respect to virtual currency, the Patriot Act, the Bank Secrecy Act, all these different, there's situations where people create systems that actually invoke what's called money transmitter license requirements. And if you are a money transmitter without having a license, there's criminal penalties for that as well. So there's all these different issues, and I'm not saying this to kind of scare you. I'm saying it because most people aren't aware of some of these intricate regulations, because they don't specifically say this applies to virtual currency, but when you read the statutes, they do, right? Because they're broad enough to cover anything of value that's moving through electronic systems. So it's just important to really kind of understand the issues there. One of the other issues with respect to virtual currency, and this comes back to the Second Life case, there's actually a class action lawsuit right now against Second Life, which is separate than the lawsuit I talked about earlier. And that is because what happened was there was a whole group of users who've had their accounts terminated, and because as a result of the first lawsuit, Second Life has their terms of service pretty clear. It says you don't own your virtual currency. You don't own the virtual goods. You only have a license to use it. Okay? And that's the right way to deal with it, actually, from a legal perspective, because of a number of reasons. But the problem that they face, and the reason they have this second lawsuit against them, is their business people were out there saying you can own this stuff, you can have real property and stuff, as opposed to saying a license. And so all these people who got their accounts terminated are doing the same thing now. They're saying you told us we can own it, even though it's in your terms of service. Your business people, your advertising, and everything else is saying, when we invested money here, we expect to get the value out, even though you've terminated our account. It's a huge problem for them right now, and it's an issue that applies really across anyone who's dealing with virtual currency is managing that user expectation and protecting your liability in the event you have to terminate accounts or other things like that. One of the other areas we see a lot of legal issues is how people acquire virtual currency. Many people have done very creative things to encourage users to partake in certain actions. Some of them kind of impact the sweepstakes or contest laws. Not that they're necessarily illegal, there's just certain ways you need to go about doing it to make sure they are legal. In some states, you need to take different actions than others because it's mostly state-by-state regulation. And then some things are actually outright, we've seen models that are just outright gambling. People have to put up money for a chance of winning virtual currency, and some of those are just clearly in the context of gambling. Last one example here with virtual currencies is the gift card and stored value card laws that, again, most of them are state by state. There's also the Federal Card Act that was passed this last year. And many people kind of scratch their heads when we tell them that virtual currency systems are impacted by the stored value card or gift card laws. They're saying we're not issuing a card. Well, again, the laws are written in a way, even though they're referred to as stored value cards, it doesn't require there to be a card. It's anytime there's something of value that's redeemable later, then those laws can be triggered. And so there's limits on what you can do with respect to charging fees, expiring accounts, and all types of things like that. In fact, some states have reporting obligations. You have to do a yearly reporting to the states, and many people are not doing that right now. Again, there hasn't been a lot of enforcement, but there probably will be more going forward. Virtual goods, again, a lot of similar issues with respect to virtual currency, some of the ownership versus licensing. To the extent that people are buying virtual goods or investing time because they think there's a certain value associated with it, you need to think about, many times you want to make changes to your system or make changes to your the terms of whether it's leaderboards or whatever it might be. Anytime you make a change, people who took certain action to get to a certain point can be adversely impacted. And we've seen a few legal issues crop up with respect to that. So sometimes, again, you want to think about those in advance. Other issues, tax issues, that's a huge issue right now where there's just not a lot of certainty. The U.S. has looked at, there's been some studies Congress has done with respect to issues on reporting with respect to tax, both from the standpoint of, when is revenue recognized or realized with respect to a virtual goods transaction? What are the reporting obligations? There really is not a lot of clarity here right now. Certain countries have kind of a little more advanced. China imposed a 20% tax on virtual goods transactions, but even their laws are pretty vague as far as what reporting obligations there are and some of the timing of recognition. So if you're giving someone points and they convert it to virtual goods, is that recognizable because the virtual good has a value, or is it if they sell the virtual good, or if it's only if they buy some third-party good, when is it? So there's a lot of issues around that, and again, there's guidance that our tax folks have with respect to this, but it's an area I think we're going to get more attention going forward. And I talked a little bit about IP infringement, but to the extent that there's anyone, kind of creating virtual goods and stuff, we're seeing an awful lot of copying out there, and one of the things that we see is that many of the platforms have really not developed really effective protection to minimize copying or to prevent it once it's found. Speaking of which, the Digital Millennium Copyright Act. One of the big drivers of actions that people try to get people to do through gamification is to encourage user activity, including users adding value to the site, whether it's reviews, sending pictures in of where they are, checking in with locations, etc. Anytime you have user-generated content, if it's your platform, there's potential issues there from the standpoint of users uploading copyrighted content of others, right? So probably the easiest example to think about is YouTube, right? We all know there's tons of infringing content on YouTube. They were just sued for $1 billion by Viacom. For Viacom said they know that there is infringing content there and they don't do enough to take care of it. The Digital Millennium Copyright Act is basically set up, or part of it is set up, to prevent liability for service providers if they host user-generated content or user-uploaded content, provided certain steps are taken. And this is the part, many people are aware of the DMCA, but don't take the relatively simple steps to comply. What happened with YouTube was that case went away on summary judgment, didn't even make it to trial. The judge said that they complied with the DMCA. There's no basis for the $1 billion claim in damages. The case is on appeal right now, but effectively YouTube's off the hook for now. So the thing to think about is that as a service provider, okay, you can really eliminate liability for uploaded content if you take certain steps, but you have to strictly comply with those few steps. And a lot of companies don't do everything they're required to do. So if you're in that situation, it's something you should really focus on and understand what you can do to minimize liability. The other thing is, if you're a content company, if you have content, whether it's movies or media or anything else that you may have, if your content is being used on someone's site and you think it's an unlawful use, you can send what's called a DMCA takedown notice, and the service provider has to take the content down if it's a proper notice. The problem is we're seeing that many even sophisticated media companies are not sending proper notices, they're not getting their content down, or it's being challenged and the content's being put back up. Again, it's not that hard to comply if you understand kind of the requirements. The other area that we think that we've seen some of this and we're seeing more and more is that there is a provision in the DMCA is that if you send an improper notice, improper as in it's not copyright infringement or there's not a fair use of your content. If you send a notice and it's improper, then you incur liability for doing it. And we've seen a number of companies, big media companies, send out shotgun letters without actually looking at some of these issues, and they're starting to see some exposure. I was given the 5-minute warning here, so I'm going to actually skip over. Actually, just one last point I want to make is that we lost a slide there, but a number of people have talked today about using points or whatever to encourage, whether it's consumers rating products or whatever. Again, there's a limit to what you can do. The FTC has actually implemented new regulations that specify that if anyone who is making a recommendation, referral, or endorsement is getting paid for that, they need to disclose that. And some of these point systems, even though it may seem minimal, the points you're giving them, depending on how your system is set up, you may have to deal with the FTC regulation. So be mindful of that if you're in that space. Okay, questions?
Yeah, so the question in regards to closed-loop value systems, so the creation of virtual currency in a system that you're not allowed to pull value out of.
Yes.
The lack of formal and regulated mechanisms to take value out of those systems seems to drive the situation where you get secondary shady markets,
yes,
where most of the illegal activity occurs and things like that. It also seems to limit the ability to profit from the exit of that value if you run that system, right? And what are your thoughts around how long that can continue before either the regulators or the actual users of those systems who have now put billions of dollars into them say, hey, wait a minute, I want some of that value back. You're giving me very soft value in, vouchers or points or something, but I want to be able to exchange that for hard value and go spend it again. It seems like it's the system needs to break here at some point in the not too distant future, because either the users or the regulators are going to say, we need a formal mechanism with which to get value back out of those systems.
Yeah, great question. So, I mean, and we've encountered situations like that, and that's really a mixed business and legal question, right? The users will respond more quickly than the regulators will. I will be certain of that. And so it's really, I think from a business perspective, again, it goes back to what I said before about you want to protect your users. How do you avoid having your users feel like they're being taken advantage of or not getting the value you're promising them or kind of advertising, because they will walk before there's regulations on that. And so part of it is, if there are illegal secondary markets or things like that, there's ways that you can kind of, we've addressed and we've shut down a number of secondary markets. There's things you need to do to position yourself to be able to maximize your ability to shut down a secondary market through a combination of steps, both your terms of service and having certain IP protection, copyright, trademarks, and other things. So you can maximize your ability to do those enforcements if you need to. But again, it really comes down to a balance there of what steps can you do both technically, legally, and from a business perspective to protect your users. You can't just rely on the regulators to say that they're going to do it, because they don't right now. They don't really understand it well enough. I can tell you that from talking to some of them directly. They're trying to understand it. They know there's problems coming, but it's going to be a while before the regulation really catches up with the business models. Listen.
I have a much less intelligent question, but
then my answer will be much less intelligent.
Good. Since reading the book Play Money a couple of years back, I've just been charmed with this concept of virtual currencies and the tax obligations, all those types of stuff. But I'm a geek. I focus on emerging technology. I have a firewall. We have lawyers in the company. I don't have to worry about that. But my wife hates it when we go to the movies because as a geek on emerging technologies, I'm always calling out bad sci-fi and video games. It's like, quantum entanglement doesn't work like that or stuff like that, and I'm the only one who cares. As a lawyer, when you see these types of emerging technology videos of an augmented reality future, with overlays or LEDs, just out of curiosity, is there something that totally irks you because that's so legally improbable to happen anytime within a decade, yet everybody seems to always use this motif? Is there something that you personally have a reaction to that maybe we wouldn't ever think about?
That's a good question. No, I mean, I think that you have to look at the context, right? I mean, I think a lot of the future is here, right? I mean, augmented reality, there's a lot of really good, I went skiing last week, there's a great real ski application for augmented reality. You hold it up and show it. I think it's cool, right? Now, some of the stuff that you see in some of the movies, you look at it and say, it'll never happen, and we may be wrong about that, right? We may think, think about 20 years ago, 30 years ago, people projected, we'd have, communicators on our wrists and stuff. It's here, right? So I think it's hard to say it'll never happen. From a legal perspective, I look at it and say that, for the most part, you can, if there's a good, valid idea, technology, business model, you can make it work if you do it the right way, as opposed to saying that'll never happen.
Okay.
I try to find the way to make it happen as opposed to saying it won't.
It seems like everybody shares the same social space, the same mapping network, the same content generation, and just legal, it seems like there's so many walls around those things that that's very improbable and stuff like that. But that's why we go to you, right? If we have those types of questions, we go to your firm.
Yeah.
Thanks.
Exactly. Thank you.
Thank you so much.
Great. Thank you.